Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Where are we? We are on the campus of Washington State University. That's one of the research institutions right there. We love research. We love technology. I'll tell you a firearms company that loves it as well. It's Franklin Armory. Franklin Armory definitely is on the cutting edge. And we're going to have to circle back to one of their firearms that was advertised as being on the cutting edge, but it turns out to the ATF, perhaps not so much. We're talking about the Franklin Armory Antithesis, a short barrel rifle that Franklin Armory claimed was not actually a short barrel rifle and therefore would avoid any of the confines of the NFA. Well, listen, after doing this video right here, we said the ATF was likely to classify these as SBRs, and that's exactly what they've done. So today, let's go through ATF's determination letter and let's talk about ATF labels the Antithesis an SBR. Okay, America, we are talking about Franklin Armory's Antithesis, a firearm which we would gladly show you an image of, but you can find them online. But if we show it here, Google's going to crap their pants. Now, we did this video right here where we said, hey, listen, there's a statement on Franklin Armory's website that is basically telling anyone who purchased one of these chambered in 5.56. This only applies to the Franklin Armory Antithesis chambered in 5.56. They were basically telling everyone, send a bank to Franklin Armory for a full refund. Why is that? Well, because even though they had a settlement agreement in place, that settlement agreement did not cover this particular firearm. And unfortunately, Franklin Armory and many content creators all got online, started pounding their chests, talking about how this was a fantastic workaround, and it obviously caught the attention of ATF. We now have a new determination letter from ATF, and it went exactly as you would expect it to go. Yes, this is now going to be classified as an SBR. We're not going to read the entire letter, but we are going to read some parts of it so you can understand where ATF came from on this one. In its original configuration as presented to ATF, the FA-15 Antithesis was an AR-type rifle chambered to fire both .45 long Colt and .410 caliber shotgun shell ammunition. This weapon was submitted with a 14.5 barrel and a 33-inch overall length. In December 21st, ATF classified this weapon as a short barrel rifle under the Gun Control Act and a firearm under the National Firearms Act. On February 18th, a federal district court vacated ATF's classification that the Antithesis was a short barrel rifle. And then they talk about what led to the settlement agreement. With new leadership in place on July 8, 2025, ATF entered into a settlement agreement with Franklin Armory that accepted the district court's ruling and classified the Antithesis as a firearm under the Gun Control Act, but not a rifle under the Gun Control Act or a firearm under the National Firearms Act. This settlement agreement applied to the FA-15 Antithesis in the caliber and configuration that had been submitted to the ATF. Okay, so this is all based on the version that had been submitted to the ATF and was subject to that lawsuit. But then this occurred. On August 28, 2025, Franklin Armory submitted to ATF for classification a 5.56 millimeter AR-type rifle under the Antithesis brand. This rifle had a barrel chambered for 5.56 NATO with standard rifling. The barrel was 7.5 inches long with a 1-in-9 twist. Thus, the rifle was the same as other standard AR-type short barrel rifles. But then Franklin Armory's workaround was this proprietary ammunition for use in this firearm. But this is how ATF dealt with that. Franklin Armory also submitted a sample of an exotic prototype 5.56 millimeter caliber saboted ammunition that housed multiple smaller projectiles in a casing. That ammunition could be used not only with the rifle Franklin Armory submitted on August 28, but also with every other firearm chambered in 5.56 millimeter NATO. So Franklin Armory, and again, I'm not being critical, they may have justifiably relied on this statement, but they may be over-relied on the settlement agreement and the ruling of the court, because ATF in their letter pointed out, pointing to the July 2025 settlement agreement, Franklin Armory asserted that because its new submission could shoot a multiple projectile load, it was not a rifle under the Gun Control Act or the National Firearms Act. But yes, but that then led to what I think is one of the biggest contributors to this problem here, was the massive amount of chatter that occurred online. Started by Franklin Armory, perpetuated by many content creators as well. That did catch the attention of ATF because the letter references it. Before ATF reached the classification, Franklin Armory proceeded to advertise online and sell an Antithesis branded rifle in at least 3 different models, all chambered in 5.56 millimeter NATO with standard rifling varying in barrel length. The models featured respectively a 12-inch barrel, a 12.5-inch barrel, and a 7.5-inch barrel. Like the rifle Franklin Armory submitted to ATF for classification in August 2025, all 3 Antithesis branded firearms are standard AR rifles, no different from other short-barreled AR type rifles sold by other manufacturers. The difference, according to the ATF, is unlike the FA-115 Antithesis chambered in 410-45 Long Colt, the subject of the July settlement agreement, these weapons were not designed to shoot both single projectile ammunition and shotgun shells. Franklin Armory's contemporaneous submission of an exotic 5.56 millimeter ammunition that could be used in any 5.56 millimeter chambered rifle reflects at most the design of a new ammunition. And this is where, in the eyes of ATF, the argument falls apart. It's not about the ammunition, it's about the firearm. It says nothing about the design of the rifle Franklin submitted in August, the sole relevant question under the statutory language. That rifle, again, features materially the same design as other standard AR-type rifles, except in one respect, its barrel length. And then this is important because ATF kind of sends a warning here that, hey, listen, we're not going to be focused on all of these new types of proprietary ammunition that suddenly allows these firearms to shoot multiple different types of projectiles. The determination about a firearm is going to be made solely by looking at the firearm, as ATF put it. ATF's position has not traditionally been that the existence of an exotic multiple projectile load in a particular rifle caliber legally converts a statutory rifle into a non-rifle Gun Control Act firearm. If that were true, the existence of such ammunition would render the concept of a statutory rifle a null set. That leads ATF to this conclusion. As ATF's review has established, there is no material difference between Franklin Armory's August submission and other short-barreled AR-type rifles on the market, which are classified as short-barrel rifles. And again, I want everyone to be careful about the messaging here, because I think there was some important lessons that we can learn from the rather braggadocious messaging, because again, ATF references it. Unfortunately, Franklin Armory falsely represented to consumers that these weapons are not short-barreled rifles and that they could not be transferred without complying with the National Firearms Act. In doing so, Franklin Armory was putting consumers in legal jeopardy because they could be subjected to prosecution by any future administration. Now, I think some of the language that ATF chose to use is a little overcritical, a little harsh on Franklin Armory. I do believe that Franklin Armory could have justifiably relied on the previous settlement agreement, but once you get into the details of it, you can see that that settlement agreement clearly would have only covered one version of the Antithesis. The bottom line here, though, is I think Franklin Armory handled this situation incredibly well. The minute they caught wind that perhaps there could be an issue with this firearm, they made very public that they needed to recall these firearms. They gave everybody the opportunity to turn them back in for full refunds. Tough situation that I think Franklin Armory has handled pretty well so far. Okay, listen, we're going to go ahead and link up ATF's determination letter down below. We're not defending it. We don't expect you to agree with it, but we're posting it down there so that you can geek out on it for yourself. You don't have to take our word for it. Now, listen, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information is down there in the description box. If you got an idea for a video we should be doing around here, you click on that link right there and you tell us all about it. If you want to subscribe to the monthly newsletter, the ability to do that is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. From the beautiful campus of Washington State University, thanks for watching and stay safe.